Great. So good morning, and thank you all for joining us today. I'm Caitlin Angus Hornsby, a corporate commercial and tax lawyer in the Charlottetown McInnes Cooper office. I'm also a proud board member of the Construction Association of Prince Edward Island. It is my pleasure to welcome you here to today's webinar to discuss a critical issue for the construction industry, which is tariffs. Obviously, tariffs have become a significant concern, and the U.S. has imposed global tariffs, including on aluminum and steel products coming from Canada. Canada and other countries have countermeasured by imposing reciprocal tariffs on imports. And as recently as yesterday, we saw a pause on some of these US tariffs, which goes to show just how volatile the situation is. In light of the current political and global landscape, McInnes Cooper was prompted by Sam on behalf of CAPEI to host this webinar. And for that, I would like to extend a special thank you to Sam, who was key in bringing this all together. We are here to provide some insight in relation to tariffs and the effects on both existing contracts and future strategies, including those sections of the CCDC contracts that are most vulnerable to trade wars. Hopefully, you will leave with sort of some contractual considerations and thoughts from a legal perspective as they relate to your business. I'm happy to introduce John O'Day, a lawyer in our St. John's McInnes Cooper office. John represents consulting engineers, architects, owners, and contractors. He is a member of the CBI Construction and Infrastructure team, as well as the American Bar Association Construction Law Forum. Following the presentation, Andrew Kinley, a commercial and construction litigator from our Halifax office, will relay a few questions which were submitted prior to the session. And if time allows, we'll also field some additional questions that might come up. So with that, John, the floor is yours.
Thank you, Caitlin. Just to let you know how I'm going to do this, I'm going to be reading some material as well during the presentation, because what I've tried to do is to incorporate some answers in some of the questions that have been sent in beforehand. So I guess I think the first thing that we have to be mindful of is this is a moving target. There's no question, I mean, based on what happened yesterday, we're at a new playbook. How long is this pause going to be? And is it likely that there will be other interruptions in the meantime? So keep in mind, anything that we're talking about today will have some bearing, but you've got to have the scorecard in front of you all the time. Anyway, so the CCDC2 is the document that I'm using, but this applies to any other similar type of standard contract. And while I won't reference others, keep in mind that the provincial government of Newfoundland, the one I'm familiar with, and I think also Nova Scotia, will have some similar provisions in their general conditions. So most construction contracts address tariffs and taxes. There's a provision in all such contracts with respect to application. HST is the default one, but then other taxes and tariffs have their own section. And the current political climate, these have now become something of a focal point, just like force majeure was during the pandemic. But keep in mind that there are two sources of tariffs that we're going to be referring to. One is the tariff that's imposed by the foreign country. The second one is the reciprocating tariff that's imposed by the receiving country. So in Canada's case, anything that we do by reciprocation, that's a tariff, and it can have an effect on the contract as well. So next slide. The CCDC2 2020, I'm going to go through some of the clauses that have an impact on the tariff, what I'll call the tariff war. In any case, regardless of whether it's tariffs or whatever else, one of the, I remember doing a seminar for the Newfoundland Construction Association, and there were about maybe 30 or 40 in the room. And as an opener, I said, how many people read their contracts front to back? I think there were only about 2 or 3 hands that showed up. And it demonstrates that when you get a contract, it might contain a couple of hundred pages, but it is critical that they be read thoroughly, particularly the general conditions. Because all of these contracts, particularly the CCDC standards, they'll probably have supplementary conditions as well, which will change the standard form. So I'm going to go through the various sections that will apply in this tariff environment. Next slide, please. GC 3.4 is the construction schedule. Now, the schedule can be affected where there are tariff issues. Simply, there could be a delay. If you have a schedule that requires that certain supply arrive on a timely basis, and let's say a certain supply has been hit by a tariff, well, the owner may say, well, look, rather than pay the more expensive, let's go to a different supplier at a cheaper price. You might find that that supply is going to be delayed because they're not available to ship right away. Then you've got to deal with a bump in schedule. There's always not always, but there's likely to be a price impact when you have a delay in schedule. So sourcing alternative suppliers for a lower cost, where that supply is not available, are you going to have a delay? Just for a comparison, the CCDC 5B has a similar GC 3.5 provision. And this is a form of a cost plus contract, though. So therefore, in that one, you will likely have an ability to seek reimbursement because it's a fee-based contract. Therefore, it's a reimbursable cost of work. So you have to look at these contracts uniquely. Next slide. So 6.3 provides an opportunity to seek a change. A change directive and a change order. A change directive is a change of the terms of the contract as stated in the contract itself, whereas a change order may add something new to it. So a change pursuant to a change directive is limited to the list of items that are set out in the CCDC 2 GC 6.3, but they include taxes and duties other than value-added taxes. So you'll find that if you look at 6.3.7.14, that's where you'll find that particular provision. And this could trigger a contractor to seek a change in the price due to a tariff change. In the CCA1, the 2001 version, the similar clause is found in SCC 6.3. Next slide. Now, 6.5 in delays. This is a bone of contention for owners and contractors, delay for any reason. A delay issue can arise and affect the construction schedule when issues arise over the tariffs, particularly when they have an impact on price. As I mentioned before, supply is one of those areas. The owner will want to tighten up a contract to exclude tariff or tax issues as a reason for a delay. GC 6.5.1 provides that where tariff issues cause the owner to delay a project, then the contractor can be reimbursed for reasonable costs due to delay. And that kind of language gives you all sorts of concern because what's reasonable costs? I mean, is a 1% change reasonable, whereas a 25% change is not reasonable? Well, it depends on the value of the material that is being affected. And again, in the CCA 2001 version, a similar section, GC 6.5, uh, can be found. Next slide, please. GC 6.6 is a claim for change in contract price. Um, Contractors are very familiar with this area, and this permits the contractor to seek a change for any reason that is beyond the contractor's control. Well, of course, tariffs will be beyond their control. There will likely be a disagreement over which party is responsible for any increase in costs. And where this hasn't been anticipated in advance, it could end up with a dispute. Is the dispute to be resolved now, or is the dispute to be punted at the end of the contract when you try and get these things resolved without delaying the project? GC 6.6.2.1 provides that if a party intends to make a claim for a change in price, then that party must first take steps to mitigate the expense. Well, how do you mitigate that? One way to mitigate it is to try and shift the burden from one party to the other, but that's where you end up with this dispute. So a higher product price that requires a contract to seek cheaper prices would be a way to mitigate. So again, going back to that example, the owner may say to the contractor, rather than bear that significant increase in price, let's find a cheaper price that keeps us within the contract value. Of course, any change in price or product sourcing could cause delays because it may take time to actually get the new supply. Next slide, please. This is where you end up with the dispute resolution process. I always like to suggest to contractors and owners that they look at this section as soon as possible. In GC 8.3.1, there's a provision to appoint a project mediator, and it gives you, I think it's 10 days to do that. I have always found that if you do that early enough, you at least have overcome one hurdle. Trying to resolve a dispute by having a conflict as to who you're going to appoint is better resolved before you embark on the project. So if you get a project mediator in place, and they don't have to be an expert in every area, but familiar enough with construction contracts. The process under which this is done is negotiation, then mediation, then arbitration, and of course, then on to litigation. As I said before, likely an issue of a change of this nature, if it can't be dealt with immediately, will likely be put off to the end of the contract when the parties have an opportunity to negotiate properly and avoid a delay. Next slide, please. Now, this is the clause that everybody seems to notice. And it is a provision that allows for a change as a result of taxes and duties. It allocates the obligation to assume responsibility for any increases in tariffs to the owner. And I'll read it out clearly. Any increase or decrease in the cost to the contractor due to changes in taxes and duties, so it includes tariffs, after the time of the bid closing shall increase or decrease the contract price accordingly. So that seems to be fairly straightforward. Be careful. Check the supplementary conditions because that may be somewhat modified. As an interesting comparison, the CCDC 5B has a similar GC 10.1, but again, this is a cost plus type of contract. So any increase in tariffs there would be a reimbursable cost of work. Next slide, please. Another section that's clearly a applicable is the 10.2, which is laws, notice, permits, and fees. Laws captures tariffs. So GC 10.2.7 provides that where there's a change in laws, the contractor can seek a change in contract price. Similar to 10.1, you can seek a change where the law has changed, i.e. where the tariff has changed. But not every change in law, that is in tariffs, results in an increase in costs that can then give the contractor a claim for a change in price. As of now, today, you could never argue that you're not aware of it. So the fact that the future may remain uncertain is now known to anybody who is going to enter into a contract. So you can't say this wasn't anticipated. So now it's anticipated. Now you've got to make your provision clear in the contract. And that requires parties who are negotiating today for new contracts to make sure that they've addressed it properly. Next slide, please. This is probably the most important part of any of these contracts, notice provisions. And I have done a chart for clients of every notice provision that's in these contracts. It's important that when you're reading a contract of this nature, that before you enter into the contract, make note of every provision that requires a notice in writing or notice in other forms. Now, today, notice requirements are being enforced by the courts in a strict manner. The back and forth on tariffs will necessitate vigilance on these provisions to ensure that the issues are addressed and identified, particularly now since this is not something new. Everyone is aware that these are going to be up in the air for some time yet. Next slide, please. Now, not every contract has a provision for frustration. If you can think back to COVID, that was an era when there was an argument being made that contracts are being frustrated because of the COVID pandemic. But standard form contracts don't make provision for a frustration event that could bring about the ability of either party to seek a termination or a pause in the contract. And frustration is not an easy pitch to make. Anyone alleging frustration has to demonstrate that the event was not its fault, the event was not foreseeable, the event was not within the party's control, and the event fundamentally changed the party's obligation. In other words, there was a material change to the obligation. So critically, you can't argue it's not foreseeable because everyone now knows it's foreseeable. So in other words, it's in your contemplation that a contract today may have to have some particular specific provisions dealing with the tariffs. And sometimes contracts will contain a force majeure clause that could provide relief. However, the wording of a force majeure clause is critical in order to result in a suspension or termination of a contract. So again, very careful drafting. Next slide, please. Now, what happens with regard to procurement in the future? There's going to be a bit of a complication in the procurement process. I would think that any front-end documents now that are contemplating to be issued in the next weeks, there are probably going to be some consideration to language that has to be changed. So be careful. If you're getting a contract from a public authority, don't think that you're getting a similar kind of a document that you did last week or last year. It should be reviewed carefully. In future, owners will need to be sure that the front-end documents are reflective of the tariff turbulence, or it's a good opportunity to review the contracts generally for areas that they may think need to be updated because of what the tariff war has provided or presented. So participants in the procurement will need to carefully examine the following elements in the process. Next slide. So bidders, whether there is a preference provision now going to be put into contracts. If you recall, I mean, certainly from the perspective of years ago, Newfoundland had a preference policy for local suppliers. Now, preference policies are not well liked because it doesn't permit fair trade. But keep in mind that this Buy Canadian, for example, is a form of preference. So whether or not you'll find preference provisions in front-end documents going forward, um, keep in mind that that may be something that you have to look out for. Next slide, please. In certain cases, you're going to need to be mindful of the trade agreements. Is there an Atlantic Province trade agreement that has to be respected? So some of these may or may not be offside with respect to changes that arise, such as tariffs, but it is, again, something that the owners or the government authorities particularly will have to be aware of what provisions need to be changed to reflect whether there is a bias by virtue of a trade agreement when you've got situations like these significant tariff changes. Next slide, please. So I suspect that there's going to be a need for front-end documents to be revised to request that certain information be made available to ensure that the information that's going to be contained in the bid document covers issues that would be pertinent to, say, tariff fluctuations. It could be part of the evaluation process. For example, if your evaluation process now contains a provision for source of supply, that may be relevant to whether a bidder is going to be able to successfully bid because their access to supply may be restricted. So keep in mind that the front end documents now may have significant changes. And I suspect that most contractors look carefully at the front end because that's particularly the evaluation provisions are critical. Next slide, please. Qualifications criteria. This may, again, this is an issue with regard to fairness, but setting up qualifications based on who can or cannot bid could be introduced. Let's say, for example, you've got suppliers from a foreign country where the tariffs are applicable to Canada. Is this a qualification criteria that you're going to put in that they have to have, I don't know, a local office in the country or a substantial presence in the country, et cetera, et cetera? So keep in mind that qualification criteria for anyone entitled to bid may change. In addition to that, for new contracts, some things that you might want to keep in mind. In the context of tariffs, contractors might want to be able to put in their contracts price adjustment formula. For example, indices that allow for adjustments in price, CPI, the Consumer Price Index, or commodity indices that allow for changes automatically to occur. Also, contractors could now be demanding more cost plus contracts, so they don't want to be caught out. And let's face it, a tariff is something that is paid by an owner. So if the contract has that provision, then you're pretty safe that any tariff changes are going to be covered anyway. But if that provision has been amended, of course, contractors have to be aware who's going to share the burden, and you got to have some careful negotiations. And they may turn around and say, well, look, we won't do this unless we're going to have a cost plus, particularly with respect to tariffs. Another way you can get around this is a contingency allowance that could be added to contracts. Contingencies are not unexpected, so why not have a provision for contingency specifically dealing with changes in law or tariff changes? Also, where projects can be delayed before the award or in mid-project, you want to have some clear idea if the tariff is going to cause that. How do you address the changes, particularly in price, that are going to have an impact? It's interesting to note that owners could consider purchasing a delay insurance. Now, I wasn't aware of this until recently, but there is an insurance policy called delay in startup insurance. So that's one area which is rather unique and could be rather applicable if you're thinking that a change of that nature could result in a significant impact on the price. Now, I've gone through that fairly quickly in order to provide some time for questions. Um, I, some of the points that I raised addressed some of those questions that came in earlier, but at this point, why don't we stop here and respond to any questions that have come in? And by the way, thank you for your attendance. I gather there's a fairly large crowd, and I hope this was helpful.
Thank you, John, for the insightful presentation on that. So we'll move into answering or asking and answering some of the questions that were raised before the presentation. And also, if you have any other ones, feel free to put them in the chat and we can answer them here as well. So John, we received a question during the presentation talking about how an owner can verify whether something is properly a tariff or if it's really just an increase in price of materials and looking to increase those amounts based on market impacts from tariffs. So what can owners do to, I guess, verify and mitigate that risk?
Question again, how can owners determine whether a change is a tariff change?
Yes, like if they, for example, if an HVAC contractor invoices an invoice with a higher cost, and the supplier has price increases and things like that, and they're claiming because of it being as a result of tariffs, how do they go through that mechanism and verify whether that's properly a tariff change or if that is really just a material cost increase?
Well, under these contracts, an owner can require a contractor to provide support for any change. So the detail would have to be provided. In fact, they could even ask for copies of invoices. So from that perspective, they'd have to provide in any information to, if it's a change, any information to support that. Also, in a breakdown, if let's say the owner has a rough idea of bill of costs for various divisions in the contract. Then when the contract is to be awarded to a particular bidder based on the breakdowns, the owner could go back in and ask for a further breakdown within the divisions to seek, particularly if they're a bit skittish and thinks that there's going to be some hidden cost in there that they could be faced with in the future or during the term of the contract. So the owner has that ability to demand that information.
Perfect. During your presentation, you talked about the future procurements and changes needing to be made to the front end documents in respect of that. Obviously, with some large major procurements, they may have been commenced and started before the tariffs and kind of the landscape we're in right now. What can owners do during that active procurement right now where they might not have had an opportunity to address these issues in their procurement documents?
Well, let's assume that the procurement document doesn't have a provision for tariffs. Let's just play that for the moment. In other words, they're not dealing with a standard CCDC. So if there's no provision there now, and is this after the award has been made?
This would be pre-award, so during the tendering or RFP process.
Well, they can always put an addendum out. If you haven't got the provision covered and you're still within that time frame for bids to be received, then you put out an addendum. If it's after that, then during the evaluation process, the owner may the owner may decide, well, we're going to have to cancel this procurement and come out with a new one. They'll pull it back because it's a significant change, so they would cancel it. Coming back with another one, there may be some argument as to whether that's appropriate or not, but a significant tariff change could be negotiated after an award if the parties are agreeable. But my suggestion is to cancel the contract, come out with a change in to include tariff issues.
Perfect. And kind of going into that same scenario, if you're a bidder involved in one of those active procurements and you're not aware of what impact or what effect an owner is going to give to the tariffs in the changing landscape here, what mechanisms or tools could you use there to address that risk or uncertainty?
Well, during the bid process, a contractor who is alert to it could put in a request for information during the process. That course then goes out to all the other bidders so that they are aware of what's going on. Otherwise, if the contractor doesn't see an element that they're concerned about that may arise, then they could put in their bid a response that doesn't necessarily respond exactly to, in other words, they put in a question. Sometimes bids that add things that are not requested could get punted because the bid process is very specific, but there's no harm in doing it if you feel that the front end documents don't restrict that kind of intervention during the bid process.
Perfect. Thank you for that. Going more to kind of the economic impact, what effect or impact do we believe that these tariff changes are going to have within the construction industry here in Atlantic Canada, and I guess with the delay or going forward with certain major projects?
Well, it's going to be rather significant because let's just take steel, for example. If there's going to be a 25% charge on steel or any product that's coming into the country that's necessary, I mean, some of these projects are going to be massive. If you think about the upcoming Churchill Falls development starting sometime next year, the evaluation of the nature of the contract, et cetera. I suspect that the Quebec government and the Newfoundland government are going through fairly serious review of what changes could occur, particularly like tariffs, that's going to cause that project to have to reconsider. Not that it's going to go not going to go ahead, but how do they accommodate it? So any project at all that's going to have issues of 25% value change is going to be a cause for pause, either to the timing of the project or to make sure that the lawyers and the engineers get pencil sharpened to make sure they got the right language in the document. So it's all hands on deck to, you know, do careful reviews.
Sure. No, that's great and interesting to hear. So this might tie into a couple of points, but we have a question from the participants, and it speaks to what if you are midway through the contract work and the contract does not speak to tariffs specifically? So we're dealing with a non CCDC2 contract. What are the options for the owner? What are the options for the contractor in those circumstances? Are we in those other provisions at that point, or do we kind of fall to the common law issues of frustration and force majeure at that point?
Well, if it's if you're dealing with, of course, today, if someone asked me today, how would you provide for it? I'd say, well, why don't you wait till tomorrow because the picture may change completely. Not a good, advice. But if you've got no provision in the contract for anything like that, then you have to start in the process of your negotiations for a change. Part of the problem that you run into there is whether there is a good faith approach to it, or one of the other parties is going to be stubborn and say, "Tough, you signed it, you live with it." You then have to consider, do you down tools? Now, in order for anything like that, as I said before about frustration or a fundamental change, anything that comes up like that will require the parties, first of all, to try and mitigate the impact. In other words, approach it in a good faith process. Because if you end up in court, that's one of the areas that they're going to be saying, look, you could have done the following to avoid this problem. Why didn't you? So if the contract gives you no relief, then it's simply a matter of, are you prepared to sit down and negotiate? And negotiation then goes to the next level. You find somebody else who can assist you in trying to resolve the issue. That means that there's possibly going to be that you're going to have to bear some of the cost because good negotiations mean you might lose a little, but you'll win a little.
Yep, no, that sounds good. As far as working as a project consultant or estimators in this kind of constantly changing landscape, what would you recommend those parties in the construction industry do, and how best to estimate these projects going forward?
Well, and the consultants, let's say they have the handle on the various types of contracts that will their clients will require. I'd say what they do now is go through their inventory of contracts and start looking at areas that they need to update. Too often, and this is not a criticism of consultants, but too often owners will say, well, we're going with this type of project. Let's use the same contract that we had last week or last year. I've seen a lot of standard form contracts over time come up over and over again. And the date on the bottom of the contract, and I'm thinking of the public authorities now, is about 3, 4, 5, or even 6 years, 10 years old in some cases. They haven't changed them. They haven't, and they go borrow someone else's. So it's time to be a little bit more attentive, and this may be a good chance to check your inventory to make sure that everything's up to date.
Yep. This was a question that we received from the attendees, and it goes back to GC 10.1, the taxes and duties. So it speaks to that it is generally agreed that tariffs are covered by 10.1 taxes and duties, and or value-added taxes, HST, things that you covered in your presentation. But in dealing with this clause, would the contractor also be entitled to a markup on these amounts associated with that increase due to tariffs?
No, and I say that cautiously. Not a markup on the tariff, but what they may be entitled to, for example, let's say the tariff is very significant. Let's say a particular supply represents 50% of the value of the contract, and that supply is going to be hit with a 25% tariff. That may be enough to cause the contractor to go to its bonding company and say, I need increased coverage. So that's an area where you're going to have an impact on a change in not only the tariff, but in the bond that the owner typically pays for anyway. So it's a double hit in one sense. The cost of that bond is going to increase, so the premium is going to be added to the contract. So the tariff plus the extra premium. So there's a double whammy impact.
Uh, Perfect. As far as clauses, you talked a little bit about your presentation now that if the parties are negotiating a contract today and given the events that have developed so far, um, what there really needs to be a need to put or insert some terms into the agreements themselves. I know during COVID there was a lot of discussion around price escalation clauses and other related clauses. Are these the types of clauses that parties should be including in their agreements at this point? And what's the operation and effect of those clauses?
Yes, it's a good idea to a couple of things come to mind. Not only a price escalation, but delay. In other words, is this going to be a change in tariffs, a significant change in tariff? If you have to deal with that issue by way of trying to find another source, then you got an issue with a delay. So uh, yes, be mindful of where the impact is going to be so that neither party is caught out. Again, it's a good idea to review the documents, the contracts, and negotiate. Once an owner changes the terms of a contract for the next round, and they take into account these things, a good owner would not just put that out as a front end without giving a heads up to the bidder saying, here's, be aware the following has changed from our standard form contract, rather than try and hope that it just flies past. Because how many of the contractors are actually reading carefully the terms of the contract? They'll probably consider it, oh, this is the same thing I got last year or last week.
Um, Based on what you've seen in the articles and kind of the ever-changing landscape that we're dealing with right now, what particular items within the construction industry are most at risk of being subject to tariffs or price increases as a result of that? Is it the steel, aluminum? Is there other categories that owners and contractors should be aware of?
Absolutely. And without trying to be the holder of any inventory list, the best place to go is on the federal government website, www.tarifffinder.ca, and that's tarifffinder.ca, and that will give you a list of items. Now, yesterday's list is not today's list because it's a moving target, but it's a useful place to go. There is another source, can't quite what we call it, but it's under um, I think it's an American site, but you'd have to have an access authority to get into it. Let me see if I can find it here in my notes. Um, U.S. site for tariffs. That's the best thing I can say. It's um, https:// hts.usi So that would be another source. Another place to go for those who have access to it, the Atlantic Province Economic Council did out a newsletter dated January 16, 2025, highlighting the economic disruption that the tariffs impose. And it contained a lot of information on what exports are going to be affected and what commodities um, will be affected. So that's just for Atlantic Canada. There are other sources as well that I don't have to hand, but I would say there's a prolific amount of information out there now that would be of assistance. Just a matter of doing the online searches.
So and this question we received online, it looks like it's directed to the CCDC general terms and conditions, and particularly CCDC2. So the question is that is it just that GC 10.1.1 plus Article 7.1.14 relates to taxes applicable to the work capitalized work defined, while Schedule A2 relates to the taxes that may apply to the services, defined services capitalized?
So give me that one again on the sections that you're referring to.
Yeah, it was. Is it just that GC 10.1.1 plus
Yeah.
Article 7.1.14 relates to taxes applicable to the work, while Schedule A2 relates to the taxes that may be applicable to the services?
So A2, I'm just looking at that now.
And sorry, that's in the CCDC 5B.
Oh, sorry, 5B. All right, I don't have that to hand. Um, Services versus goods.
Uh,
Um,
yes. And we can take that one offline and get back to that participant as
yeah,
well, and deeper
I'd
look
like,
at the agreements.
yeah,
So going back to a little bit of the discussion about delay, and when we're dealing with these delay scenarios and characterizing it as excusable or non-excusable delay, and also compensable and non-compensable delay, is the availability of supply or the lack thereof, the non-availability of supply, is that something that's going to fall in the categories of excusable versus non-excusable delay? And is this going to be a compensable or a non-compensable delay?
uh, there's two ways to approach that. Anyone who's bidding on a contract should know their source before they bid, because obviously, if they haven't checked out sources and timing of delivery, then bidding on it without any exception is non-compensable in my view. If it's a change on supply during the contract, that clearly they're not going to be the only ones in that ballpark. So let's say that the issue is steel. Well, every contractor across the country who's got to deal with steel has got to find another source. So you're going to be part of a large group. You're lining yourselves up to find another source. Well, you may be the back of the boat by the time you get there. You could be the first one in line, and you're lucky. So it's a matter of timing, and lack of supply can be compensable if your mitigation is appropriate. So you've got to be able to mitigate, and this is where the parties have to work together. I mean, if everybody could do an integrated project delivery type of contract where everybody opens their book, so to speak, that's great cooperation. But not all contracts have that kind of openness. But um, how how you approach the mitigation could be very much whether you are going to benefit from an adjustment.
Sure. And with that in mind, John, you talked a little bit about in your presentation the notice and importance of providing notice. And I know that the CCDC contracts contemplate providing notice of delay and so on. In mitigating or managing that scenario, when is the best time to provide that notice? Is it when you have a belief that you won't have the availability of those materials, or is it when you're not able to do it? What's the best timing to approach that situation?
Well, again, it's the language of the clause. Some of the provisions require written notice. Others say no provision for a particular number of days, written notice, or whether it's calendar days or work days. Um, Anytime that you're aware of anything that could have an impact, it's well worth bringing it up. Don't wait until it's actually confirmed, because again, it's, were you aware of something? Could you have done something to mitigate? Well, if the time for mitigation passed by the time you brought it up, well, you're going to be out of luck. So again, it's a matter of language of the contract, of term, the particular term, or it's just common sense. If you know that there's going to be an issue, address it now.
And on that note, you also spoke to a product that there's this delay or startup interruption insurance. Um, is this something that's been within the industry for a while, or is this something new? And who are some of the main providers of
It's new to me. I don't know what insurance companies would have it. And I don't know if it's more appropriate for the owner or the contractor, or even if the contractor can get it. But it's just something that I happened to come across in my reading, and I said, "Oh, this is rather interesting." I guess insurance companies are prepared to insure any bet. So if you want to bet that there's a delay and there's a premium for it, well, why not? It's like I guess it's a form of after the fact bond.
that? Yeah. No, and it was news to me to hear about it in your presentation. So going back to the delay topic, I think you said this as well in respect of a question that you answered about how we approach the agreements now and knowing this tariff landscape that we're working with. But this is a clause that the parties should be looking at more closely and negotiating around that and what's properly a delay and what's not properly a delay in these circumstances.
Yeah. I did a survey some time ago on a presentation I did for the Newfoundland Construction Association. I asked those who were going to be attending to answer a couple of questions. And I was trying to find out where their pain points were in contracts. Delay was top of the heap for everybody who answered, because delay issues for an owner obviously is critical, but for a contractor as well, because if they're delayed, are they going to be able, for example, for a contractor, I'm delayed on project A, I got project B coming up after this, my crew is going to be held up on this delay, I can't get them available for project B. A very simple example of um, an impact for a delay. Now, not all delays are going to be significant of that nature, but delay issues apparently seem to be the high point, at least at that time when I was um, giving that presentation.
Yep. No, that sounds good. And this relates to a question answered or asked by the attendees, but kind of what is the best time to involve legal counsel in dealing with these issues? For example, should it be at the procurement stage, looking at the procurement, what's involved, what the agreements entail, and so on? Wait till a dispute, or later on, what's the best time to involve counsel to deal with these issues?
I would say now, today, at soon as something comes out on Merck's or any procurement, platform, and you're interested in looking at it or bidding on it, I would say get in touch with your lawyer and ask them to look at the front end documents, because there's no question uh, there is likely to be certainly after this tariff war, changes in provisions. So whether it's from a government authority or from a private contractor, ask your lawyer to have a look at the front end. And that's particularly, it'll be in the instructions to bidders. It might be some notice, but more than likely you're going to find it in the general conditions and any supplementaries.
Correct. No, recognize that we're kind of running to the end of our presentation here, but thank you for all your insight and knowledge and addressing these additional questions with your presentation. So thank you so much for that. Believe that for the large part concludes our presentation today. Caitlin, I don't know if you have any concluding comments.
I guess it would help if I wasn't on mute. No, I just wanted to thank everybody for coming, and like Andrew and John said, if there's any follow-up questions that anybody has after the fact, we're happy to reach out to you on those things as well.
And just as an ad, I don't know if it's possible to do this, but if anyone wants to get a copy of a document I created for some clients generally on notice provisions in the CCDC2, I can make it available, but not sure how that could be done, Caitlin.
Well, if anybody knows me, I am not the person to ask as far as that would go, but I think Janica could help us disseminate any information that we want to after the fact.
Good. Thank you for the chance to do this.
Thanks,
Perfect.
everybody.
Thank you. Thanks, everyone.